deny the motion to adjourn because it's not properly in front of him. So,
Well, all I can say is that, I mean, this is a very profile case. There's a lot of claims regarding the best interest of my kids. Like this is, it needs to be done at a very high level for the best interest of my kids and prepared carefully. And because of there's false accusations, there's concerns with
well, let me get you straight first. Let me get you straight first. Whose false accusations? Miss Shepherd, Miss Judd, or your kids?
Miss Shepherd.
Okay. All right. Okay. So
And there's a lot of again, this is a very complex matter, especially when it's pertaining to the custody of my kids. We can have a really detrimental mental health status with me potentially losing custody of my kids, and this needs to have proper legal counsel to not only gather the supporting evidence to counter her claims, which takes a little bit of time, but again to gather supporting evidence and to have again proper counsel and defending these accusations.
okay, thank you. All right, let's get to Ms. Judd's motion, please. I read your motion, Ms. Judd. Is there anything you would like to add? I do have a few questions for you after you've said what you're going to say.
Of course, I tried to be thorough in the motion itself. I guess I wanted to just address one comment that Mr. Shepherd made.
In today's case, we're diving into a high-stakes custody battle that's turning into a courtroom war. One parent claims false accusations are being made against him, while the other warns of escalating psychological harm to the children. Therapy notes reveal terrifying behaviors, allegations of parental alienation, and a household full of tension.
Received the email by the following night, as he had then on Thursday taken it upon himself to have the children playing a first-person shooter game, having them pretend all the enemies were NP, my client's paramour. This has escalated to a really concerning level, and I'm really worried that somebody is going to get hurt here. So I'm trying to be thorough and forthright in my disclosures. This was originally accompanied by an ex parte request, which was denied with a suggestion that CPS be utilized. But my client has utilized CPS. They've been contacted 3 times now by the child's therapist, the eldest child's therapist, to no avail. I read that myself in the therapy notes. I did not disclose all of the therapy notes. I quoted some significant portions of them, but I'm trying to respect these children's privacy. And I suspect that CPS isn't stepping in because a majority of this is psychological, less the admitted slapping that was littered throughout the therapy notes. I've got a nearly 10-year-old girl now without a bedroom, reported to her therapist to be sleeping on a kitchen floor. So something needs to change here. My client does not want to cut Mr. Shepherd out of these children's lives, but he's not participating at all in their therapy. I think this has become somewhat of a game, but these kids are suffering. These kids have now documented disorders. They are scared of him. They are being harmed in his house, and he's on some crusade.
Asterisk. Right from the start, Mr. Shepherd frames this as a high-profile case with serious implications for his children. He's emphasizing the need for careful legal counsel and paints a picture of himself as a concerned parent under attack. But what's interesting here is how often he mentions false accusations without specifying evidence yet.
Kids are terrified. They're terrified of the situation. They're terrified of retribution. They're being physically disciplined as a result of all these disclosures to their therapist and to my client. And Judge Gottlieb has already given Mr. Shepherd a stern warning to move on. Let it go. The divorce has happened. My client has moved on. Everybody can move on and be happy. We just need Mr. Shepherd to get on that train. And I'm not sure what the roadblock is here, but I think we need to look into the root of this concern, because his taking his anger out on these kids is really escalating to a concerning level. I think at a minimum, we need to implement a supervision requirement until we can get into this. I think it would be imperative for him to participate in their counseling for once, so he can hear firsthand what kind of psychological trauma this is causing to the kids. And I would also request verification from a medical provider of some kind that he's even cleared to drive, because we've got a history of intermittent seizures. I don't know if he's being cared for properly by a medical provider. I have no idea if he even is cleared to drive. I'm not sure if he's had subsequent seizures, but like I said, I'm really worried here that somebody's ultimately going to get hurt. I would prefer that not to happen. So my client has turned to this court for relief.
Thank you. The question I have is, and it's somewhat concerning, when I read your paragraph 50.
Asterisk. Now, Miss Judd steps in with a strong, detailed motion. She highlights that the children are not just emotionally stressed, they're being harmed. From playing first-person shooter games that target her client's partner to potential physical abuse, she emphasizes the urgent need for supervision.
That your client agreed to a consent judgment of divorce was with that paragraph in there. And that seems to run afoul of when they raise the right hands and tell the referee or judge that this judgment is in the children's best interests. Paragraph 53 somewhat indicates that it's not, that it was only done out of convenience by your client to get this done, and I'm troubled by that.
Oh, I certainly didn't mean to suggest that, Your Honor. I was suggesting that it was important to Mr. Shepard to have the label of being a joint physical custodian. And despite the reality of the schedule operating in a manner that had rested physical custody with my client, at such time as the mediation was happening, we all just agreed to have the label of joint physical custodians, with everyone being on the same page that we didn't have a joint physical custody arrangement. The parenting time schedule doesn't dictate a joint physical custody arrangement. And subsequently, because of her attending the medical appointments, her spearheading the therapy, her spearheading the school activities, she really is the primary custodian. I had referenced that merely to address the burden here moving forward. I certainly didn't mean to suggest that my client had created any kind of false impression to the court. The parties were getting along a little better at that time. And like I said, in the judgment, there was intention of...
Asterisk. The judge raises a critical point. Why was the consent judgment of divorce agreed to? Paragraph 53 implies it may have been done more for convenience than the children's best interests. This is a pivotal moment. Judges want to ensure that custody agreements are genuine and reflect the actual care of the children, not just a formality.
Client. That's what I had intended to suggest.
Also, the last question I have is, then we'll hear from Mr. Shepard. Why hasn't, maybe he has, I don't know. Why hasn't NP gotten a personal protection order?
I believe he's in the process of doing that, Your Honor.
Okay.
And frankly, the answer is everyone's been trying to keep the peace, but...
Yeah, that would be, because I don't know about your initial thoughts, but a PPO against a, is it a live together partner or not?
It is as of recently, and that's what has sparked the escalation and the comments to the children.
Because that could sure complicate things.
And that was, yes, and that was the other reason why there was hesitation, because I mean, my client, frankly, like I said, has been at war with herself as to how to handle this, because she's trying to keep the peace. She genuinely wants to be able to get along for these children, but I'm not really sure what else she can do at this point.
No, I think if these are true, and I don't know if they are, I'm just going by what I'm hearing. And that's why I asked Mr. Shepard, who's not being truthful, because obviously these threats are at least alleged threats are being made from the children. So I guess it would mean that the children are not being truthful, but we'll cross.
Asterisk. The judge probes about a personal protection order against the new partner, hinting at potential risks. Miss Judd confirms that the escalation is tied to this recent relationship, showing how blended family dynamics can complicate custody cases. What's striking is the balancing act. Her client wants peace but also safety.
Mr. Shepherd, your thoughts, please.
Yeah, there's a lot of points to go over there. So, yeah, excuse me if I jump around a little bit. I was actually on call last night
Me
working
too.
in the morning on a mental health case. So, first thing is, there's a history here of parental alienation that I originally presented to the court, but evidence wasn't allowed. They did not want me to allow me to present that. First of all, our daughter, let me get my notes here. So first of all, our kids do have an adjustment disorder and do have anxiety, but there's a lot of factors that affect that with children. Our daughter has a very high genetic and environmental risk for anxiety. In fact, clinical literature shows that she has an 85 to 90, 80, between 80 and 90% chance of predispositioned anxiety because of, first of all, Jenny and I both have a history of mental health disorders with anxiety. When you experience multiple residential moves, when your kids do have issues with learning, all of these things in conjunction, give you a high disposition of having anxiety. So there's a lot of other factors that affect, our children's mental health that are not being, discussed. And then you throw in, you know, um, having, there's basically research showing that introducing a step parent as a parental father figure to your children early on before the age of 6 can have a.
Asterisk. Mr. Shepard's response is detailed, but notice the pattern. He repeatedly shifts the focus to genetics, environmental risks, and alleged parental alienation. He also disputes the seizure claims and alleges gaslighting. This is a classic defensive posture in custody disputes. Emphasize mitigating factors, challenge opposing narratives, and frame your behavior as reasonable.
Like, for instance, like bringing him to games and having him take my kids to like their events, which should be done by the both primary parents. Um, Having the boyfriend take father-like pictures and then